the era where, there was this whole abuse of power is far gone. Our laws must be made to work. Bernard, whether the man is present or not, the question we need to all ask ourselves is, what stage is the OSP in terms of his investigations? Is he considering Ofori-Atta as an accused person or a person of interest? That is he done with his investigation such that he has established that there's a prima facie charge against Ofori-Atta? You see, Ghana is the creation of law, and we must respect the law. It doesn't matter whether you hate the person, whether in your imagination you think that the person has committed an offense. It doesn't matter. We must, begin to enjoy the fruits of the fight we all pursued before 1992, which is that even the worst of criminal that the person that you've even seen caught red-handed committing an offense must be taken through due process of law and not an imagination of somebody. Otherwise, we risk going into the very era that we all wanted to avoid. We must, let me repeat, begin to enjoy the fruits of the battle we all waged before the promulgation of the 1992 Constitution, which is that let rule of law prevail. You see, you can say, hey, procurement breaches, whatever you want to talk about. At the end of the day, right, the question is, has anybody established a prima facie case against Ofori-Atta? If no prima facie case has been established against him, you only need him to assist you with your investigation. Can you proceed with the investigations with or without him? In any event, he will come and write a statement, right? Other people, there are other actors around. He's not the only person necessary for the investigations because there are other people around. The contract was signed by somebody. The procurement processes, whether or not it took place, is obvious, right? PPA is there, and so on and so forth. And so, if you need him for the investigation, that will be different. If you don't need him for the investigation, that's also different. If you need him for the investigation, he's not available, charge him. There's a procedure for charging a person under our laws. Even when the person is absent, there's a procedure. Otherwise, people who leave the shores of this country, right, will go scot-free. It is not for nothing that somebody like Sedina Temaklo, even in her absence, right, the processes still went on. She was convicted and she was sentenced in absentia, right? And so let the law work. That's the problem I've always had with the OSP. It's the same thing he did in the case of Charles Bisu. Right? He gets frustrated with the court processes. So he thinks that the trial in the media works for him. Right? But that is not the Ghana we all dreamt.
Let me get you clear. You're saying that even in the absence of Mr. Ofori-Atta, the OSP, depending on what he believes Mr. Ofori-Atta has done, can proceed with whatever he wants to do.
Yes.
Without being stalled by his absence.
So let me ask you. So what is the status of Ofori-Atta as far as the OSP's investigations are concerned? Has he charged him? Is he a person of interest? So what power does he even have to declare him wanted without recourse to the court of law? Ghana is a country is a creation of law. We must respect the laws of this country. It's the same thing he did with Charles Bisu. Let me tell you. He had come out, made the media in Ghana believe that he had procured an order for arrest. And so there was a whole broadcast in this country that he had procured an order for arrest. When we went to court, he denied the existence of the order for arrest. It was on that basis that the judge made the order for interim injunction. Subsequently, he says there's no order for arrest. There's no order for arrest. There's no order for arrest. Because he's aware that sitting in his office, he doesn't have the power. He must go to the district court to procure an order for arrest.
But can he not summon a person to appear before his investigators regarding allegations?
Oh, he can.
So is it not in that context that he's declaring the man wanted, that he wants the man to appear to assist in investigations, and the man is not availing himself?
Look, under the Constitution of Ghana,
Yeah.
you have a right not to incriminate yourself.
Okay.
Are you aware? And so that is why when a policeman confronts you on a matter, he reads to you your caution statement that you have the right to remain silent. Otherwise, anything that you say will be used against you in a court of competent jurisdiction. What it simply means is that even if I appear in your office, I can choose not to talk. And so invariably, you don't need me to proceed with your investigations because I cannot speak to incriminate myself. So the presence of Ken Ofori-Atta in the office of the special prosecutor is not necessary.
It's neither here nor there in your view.
Neither here nor there. If you have done your own investigations without his assistance and you form the view that there is a prima facie case against him, charge him.
Even without speaking to him?
Charge him.
On the face of the evidence you've gathered?
Yes, that is why we say prima facie, on the face of the charge. Right? Because when he appears before you, he can choose to keep quiet. Okay, so are we saying that if he keeps quiet, you cannot charge him?
I get you.
Is that what you are saying? And so if he can keep quiet, then you don't need his presence.
But assisting in investigations may not only be in talking. It could also be in asking you to provide some information, whether that may be documents.
Go to court. Procure an order. When he appeared before us, did he say that he has procured an order of the court for him to produce a certain document or material?
Interesting.
That he cannot find him to enforce that order of the court?
So in your view, what is he doing? What is the OSP doing with this?
It is just the normal public show he has always embarked upon. It is
that how, but you've cited only one. You've cited only one example.
We saw Cecilia Adapa. He gets frustrated when he goes to court and lawyers come to face him. He thinks that whenever he has to prosecute a matter, a lawyer shouldn't even stand in front of him.
Is that what he has told you?
You see, if he walks like a duck, quacks like a duck, then it is a duck. It is a duck.
Interesting. Let me take Mr. Kwebu's reaction briefly to this, and then we move to the next topic. So, Mr. Kwebu, your colleague here is actually saying, look, there's nothing preventing OSP from doing his job, even in the absence of Ken Ofori-Atta. From a legal point of view, do you agree with him?
No. You see, let's say, yes, I agree to some extent, but it can't be 100%. You see, he is largely right that it's the prosecution's burden to find their evidence. It's not for Ofori-Atta to give it to them, even though sometimes an accused or a suspect can confess. So, Baffour, that's where I depart from you. Yes, the investigator.
So you are hoping that you appear and confess. You are hoping that he can.
Let him finish. Today we are. Just don't worry. Let him finish.
Yes, because you don't know what will happen. So, Baffour, that's where you overstated it. You have a strong point, but you've overstated it. Listen. Because there is a chance that he can confess, you have to offer it to him. So in our jurisprudence, it's not the norm, Bernard, and you can call me Martin. The people is too much, okay? Martin, or just people, but not the mister.
Okay.
You see, Bernard, the thing is that in our jurisprudence, what Baffour said is law, that the prosecution should find their evidence. It's not for Ofori-Atta to give it to them. But also in practice, there are some people who, for some reasons, which we can't go into, it's even beyond the scope of this program, they later feel remorseful and want to spill the beans. So you have to offer it to them. So as I sit here, Bernard, this is my 18th year at the bar, I can't readily recall a case in which the police just took the case to court and didn't offer the accused to write his statement. So see the practice. So Bernard, I need us to get this very well. 18 years, I practice very well. I mean, everybody knows that I go to court. That's why I can talk on the media, because I'm able to earn a living out of the courtroom. I haven't been involved or seen another lawyer discuss a case in which the prosecution have gone to court and have no statement at all from the accused. No, they'll offer it to you. It's for you to write on it. No comment. Yes, and if you write, I mean, there are some statutory parts. You heard Baffour say your Miranda rights. your right to silence, right to cancel, blah, blah, blah. So they will write all that on the paper and now say write. Or if you cannot write, speak the language you speak, and then they will get interpreter, then they will write. So when it comes to that point, it's within your right to say no comment. And if you say no comment, then they say, is that all? You say yes. Then they say, okay, sign against it. So that's the practice. So it has to be offered to him. But sometimes, if you are lucky, it's offered to the opportunity to make a statement. And the person goes ahead to confess straight. Look, let me show you the treason case. Let me just show you one case. The treason case that ACP Agyei was just added when he was not a part because Godfrey Dame wanted to just show him power, right? There is one of the accused persons, I think that's Zipi. Look, they had no evidence against him. But when he was offered the opportunity to write, then he put himself right in the suit and incriminated himself left, right, center. If you read the judgment, you can see the judges were like, "Ooh, it doesn't happen that often." So he offered himself up. The prosecution had no evidence against him. So therefore, don't overstate it. Just like what I've done. Let's do it that way.
All right. Let me give you. That's fair enough. Let me not belabor the point. I wanted a quick comment from both of you on the raid itself and the way it's been reported. We don't have all day.
No. So please, let me say.
You want to respond to that?
You see, law. You don't make assumptions. What he's saying is an assumption that I'm assuming that you appear and confess. Right?
No, he says given a chance.
Wait. The fact that he's admitted that there's the possibility of the person not commenting, right, is enough. It's enough for us to accept that in a criminal matter, it is possible for the prosecution to proceed without a comment or a statement from the accused person. The question that should be answered by him is that in that circumstance, what is the prosecution going to do? If the prosecution's case cannot be sustained, if you cannot procure a safe conviction, right, without the statement of the accused person or the interested person, then what's going to happen to the matter? So you don't make assumptions. Martin should refrain from making assumptions.
Well, there are two legal positions that we can live with. I want to proceed. I want to move forward. I want to move forward.
No, but you see, the way he said, Baffour practice. I've also practiced for 15 years. He knows. I've lived and drank in our courtroom. From the High Court to the Supreme Court. That has been my life for the last 15 years. And he's aware. Very respectfully, 3 years difference. I agree. But the complexity of the cases you've handled over a period of time determines...
No problem.
I wanted to ask you... So it's not about the number of years at the bar, even though we defer to...
Baffour is fine. In Parliament today, a lot of the arguments were more about the raid than even the substance of the OSP's claims.